The Supreme Court is currently hearing some important cases. One is Louisiana versus Calais. The case is centered around the Bayou State's congressional map and could decide the fate of the Voting Rights Act.
Members of the conservative majority court raised concerns that states like Louisiana were going too far in drawing a majority-minority districts to comply with protections in the 1965 law. They're signaling that they could move to limit the use of race in redistricting. Voting rights activists have raised their concerns that could disenfranchise some minority voters.
All right, we want to bring back in our chief legal analyst, Khalif Rhodes. Khalif, we know that Justice Thomas has really wanted to take a look at this, something he's talked about at length. What do you make of this lawsuit, and could this be Thomas's attempt to finally take down the Voting Rights Act?
Yes, Thomas has talked about this type of case in other cases, saying, listen, we should go back and review the Voting Rights Act, even when you talked about abortion, listing and naming this case as something, and these types of cases as something he wanted to address. And he talked about it in the intro, so I'll make sure I hit on it here. This case will hinge on the Voting Rights Act of 1965, specifically Section 2. Louisiana had already been held that they had their primary map had one voting district, and it was unconstitutional under the Voting Rights Act. So what Louisiana went back and did was add a second majority-minority district, and that's what is issue here. If I can easily break down this argument, is akin to when folks were doing the reverse discrimination claims for affirmative action, suing law schools and institutions, saying that the very laws that you put in place to ensure that African Americans were given access to these institutions are now discriminatory towards white Americans. That's what they're saying is being done here in Louisiana when Jason says that they're going too far. But I think we have to go a step further to figure out how we even got here. We needed the Voting Rights Act of 1965 for a number of reasons. Why? Because after the Civil War, after the 15th Amendment, after Congress had already told states that they needed to stop doing what they were doing, specifically in the South, they had created this machine, this systematic system of discriminating and disenfranchising Black American voters. And so they used literacy taxes, they used poll taxes, they had white primaries, they had voter intimidation. These are all things that were documented as to why you needed the Voting Rights Act of 1965. And so to now say that those things were unnecessary or still not necessary, then you got to go and look at statistically why they are still necessary.
Khalif, how important is the timing of this ruling on Section 2 of the Voters' Rights Act, especially with midterms being this year? Because you got South Carolina, other states are watching to see what the High Court decides to do with Louisiana.
Yeah, I think the timing of it is crucial, but I think the timing is less about primaries and voting and more about just the court. I often say that you need a good facts, good court, good timing, and a good case for it to go before the Supreme Court. And Justice Clarence Thomas has been pushing this type of case to get in front of the court so he can address it. The Voting Rights Act has already been eroded a number of ways throughout the last maybe 10 years. Specifically, before a state could make any changes to their voting rules, they had to reach out to the Department of Justice and to get authority to make those changes. Last 10 years, that was eroded, where no longer that was required, specifically in states in the South and a couple counties in Michigan and the Midwest. What I can tell you is the Voting Rights Act does not require a majority minority district, unless one thing, if you do not create that district, those voters would be disenfranchised. There will be less opportunity than other members of the electorate to participate in the political process. So there's no requirement for Louisiana to create a minority majority district. The issue is, unless, and that's the key word, unless there's less opportunity for them to participate. And the state of Louisiana has determined that it has been historically and still currently is. That's why they created these two districts. That's what's going to be at issue in this case.
We talk about redistricting a lot, right? It's going on all over the country. So what would this ruling ultimately have on states like Texas and California, North Carolina, who recently redrew their maps? Do they have to go back to the drawing board again based on what happens here?
I don't think they would have to go back to, but I think a lot of states that specifically want to find ways to remove some of these majority districts, they would then go back and redraw these districts. The crux of this is that you can't use race as the determining factor when drawing the districts. But if you have an opportunity now to go back and say, I don't have to contemplate if minority voters have less opportunity, then now I can go back and redraw these maps. So I don't think they'll go back because they now have to go fix something. I think this opens the door for folks to now say, I can draw the maps in the manner in which I've been attempting to draw them since the 60s.
Again, our chief legal analyst, Khalif Rhodes, weighing in on that for us. Khalif, thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.